Welcome to the Fund2000.com real estate podcast. My name is Chuck Ham. I'm the broker and attorney with our office, and this is Oli. Welcome, Oli,
Hi,
soon to be broker.
soon to be broker,
How's that
hopefully.
going?
Good. One last exam and then hardcore preparation.
You've got all the experience now, you just need the education. Today we're going to talk about dispute resolution in the CAR residential purchase agreement. None of this podcast is legal advice. Each person's case and circumstances might be different, and we recommend you contact an attorney. All right, so this is page 14 of the CAR residential purchase agreement, something we deal with all the time, the dispute resolution page. And this is the page where our clients have to initial. And, from my perspective and my experience, and you were telling me earlier that it's not so much for you, my experience is that people want to know, should I initial here or not? What do you think? Is that your experience or not so much? Or what do they say usually?
With my experience, people just want to sign. If they want a house, they want to sign. They don't want, or like they want to sell, like nobody wants to deal with it. And everybody kind of trusts you, which is, I think,
So,
silly.
they ask you to whether they should sign or not, or they just go right through it?
No, they just go right through it. There was no questions about what should they sign. As soon as I am sending them the documents for signature, they don't even question it.
I think my experience is different because I have a different approach to the agreement. I try to explain things for my clients, and I, I like that approach. I think my clients like that about me. To explain what the contract says as they go. And often my clients ask me up front, maybe because they know I'm willing to explain. I don't know. I guess also more the more we go to electronic signatures versus in-person signing, people are probably doing more of what you're talking about than just signing everything that's there. Would you agree with that?
Yeah.
Well, this dispute resolution portion of the agreement is important because you're agreeing to provisions of the contract that are optional. You don't have to agree to the arbitration clause in the current version of the purchase agreement. Before, you had the option to initial both the mediation and the arbitration part of it. Now there are no initials for the mediation part of it. I think you could still say you don't want to participate in mediation by crossing it out and probably adding a paragraph to the purchase agreement saying that the parties do not agree to mediation or arbitration. But if you leave it in its default format, uh, it'll be part of the agreement. So does that make sense?
Yeah.
Now, arbitration, you do have to initial. You can choose not to initial. Both parties need to initial in order to create a binding agreement to go to arbitration in the event of what? A
Conflict.
conflict,
Dispute.
a dispute. So, what is the purpose, before we get into what's going on here, what is the purpose of dispute resolution?
To resolve the issue in the most financially efficient way.
The main idea is that this agreement sets up a very informed decision making process. And that's why we're doing this podcast today, also. The purchase agreement is pretty good about setting up an informed decision making transaction. The seller makes disclosures about the property, the buyer gets to investigate. Both parties should have agents to be able to talk about the different issues about the contract itself and be able to make a decision that they feel comfortable with without needing attorneys, without needing a lot of extra help. During the transaction, the help is available, but you don't necessarily need it. So, this discussion is now what happens if you end up having a dispute that the parties cannot resolve through regular communication through the agents. So again, we're on page 14 of the residential purchase agreement. At the very top, you see liquidated damages. We're not going to get into that today. Mediation is the next paragraph. It says, mediation, and the parties agree to mediate any dispute between them out of this agreement or any resulting transaction before resulting to arbitration and before trying to litigate through a court action. So the agreement says that the mediation shall be conducted through the California Association of Realtors Real Estate Mediation Center for Consumers. So it confirms that it is the CA. It says right in the agreement, it is the CAR mediation service. Gives you the website. You can check it out, consumermediation.org. And if you go to the website, it tells you what the fees are. So there are some fees to get started. Do you remember what the mediation agency charges?
I think it's about $500
Yeah, it's 500, and the buyer and the seller split the fees. So if the
if they
if
agreed. If
yeah,
they
so if both parties are agreeing, one part, the initiating party pays the $500, the second party agrees to participate and pays 250, which gets credited back to the initiating party. And then you have an additional fee hourly. Do you remember what it was for this service?
250? No?
Yeah, I think it was 200, something like that per hour. And I wanted to look at jams. I don't remember. There's another very I don't know if it's popular or not, but it's common. You hear about the jams mediation service all the time. JAMS. You can look them up if you just do JAMS mediation services. You'll find their website and look up their fees. I wanted to see if how they compare, but I didn't have a chance. So basically, the parties agree to which service they want to use. If they can't agree, then they never actually initiate mediation. And the failure on one party's part to engage in mediation, if that party agreed or if both parties agreed to mediation on the page 14, that could have some consequences. So if you agree, if you're a party to a purchase agreement and you're agreeing to participate in mediation, then you have to participate in mediation if there's a dispute. And do you remember what some of the consequences could be if they fail to?
Well, you might lose the case. It's basically you're forfeiting.
Well, yeah, that's true. You could lose the case on the merits because you just didn't participate and present your evidence, right?
Hmm.
But not at the mediation level. There's another consequence that I have in mind. It's the attorney's fees part of it. What happens?
Oh, so you will have to pay if the other party prevails, you will have to pay their attorney's fees.
Right. Yeah. So attorney's fees are available under the California purchase agreement that we're discussing to the prevailing party. Both parties. Now, you could change this if you decide you don't like that provision. You could change it, but there's no way to change it unless you actually work with an attorney, probably, or with your agent to change that part of the agreement. The default is that the prevailing party will get attorney's fees. So if you drag somebody into court, you sue them because of a dispute, or initiate arbitration, mediation, all that, and you cause them to incur attorney's fees, and then you lose, you're going to have to pay their attorney's fees under this contract. Does that make sense?
Yes. And that's if you like if you go through mediation. If you don't go through mediation.
Well, that's in any scenario.
Okay.
That's in any scenario except for what it says here. If you're a party that refuses to mediate when you agreed to mediate, then and then later you prevail, then you don't get to get your attorney's fees. That's the consequence. So the consequence I was alluding to earlier is what I just said.
Hmm.
If both parties agreed to mediation and arbitration, and if there's a dispute, one party initiates, the other party refuses to mediate and arbitrate, the refusing party, they could still end up prevailing on the merits later, but they're going to lose their attorney's fees because they did not accept the mediation invitation and the arbitration invitation. So that's the interesting thing here is attorney's fees. It's a big deal because that could be more than the actual value of the dispute in the first place. I mean, it depends on how much time your attorney takes. Now, on the other hand, mediation and arbitration, they're supposed to save you money, right? Versus litigation.
You, I guess you don't have to have an attorney there.
You don't have to have an attorney. That's another good point to make. You're not required to have an attorney. And you reminded me of another part right underneath this mediation paragraph, or actually right, no, right underneath it. So you have paragraph 27, both A and B. B says exclusions from this mediation agreement are specified in 28B. So look further below. Exclusions, that's 28B. The following matters are excluded from this provision requiring mediation and arbitration: any matter that is within the jurisdiction of a probate, small claims, or bankruptcy court, an unlawful detainer, that's eviction, a judicial or non-judicial foreclosure, or other action or proceeding to enforce a deed of trust, mortgage, or an installment land sale contract as defined under the Civil Code 2985. If your action is any one of those things, probate, small claims, bankruptcy, eviction, foreclosure, um, and those kind of things related to a deed of trust or mortgage that are listed there, then you don't have to go to mediation first, even if you agreed to it. So you have these exclusions. Okay. All right. So what is mediation? What is your understanding of mediation?
Both parties are meeting with the neutral party and trying to resolve the conflict before going further.
Right. And how is the conflict resolved? What is the end result, I should say? What is it you're trying to get out of this deal?
Both parties agree on some kind of outcome together.
Right.
It could be finance, it could be payment, or it could be just giving up the case. It's any kind of outcome.
Right. So the final resolution is going to be a contract. It's going to be an agreement. It could be called a mediation agreement. It could be called a settlement agreement. It could be called mediation settlement agreement. Usually it's going to be something like that. And if the parties fail to agree, what happens?
Then it goes to the arbitration.
Then it goes to arbitration. So we have a mediator. He's neutral. He's going to try to help the parties come to an agreement. And theoretically, the parties ought to want to come to an agreement. They ought to listen to the mediator based on their expertise. Hopefully, they have good expertise in real estate matters. Um, Back to the mediation paragraph here. The mediation paragraph recommends somebody. Let's see, is it this one or is it the arbitration one that recommends somebody with experience?
I think it's arbitration.
Yeah, you're right. If you were to go to consumermediation.org, you would definitely get somebody with real estate experience mediating your dispute, and probably the same with JAMS, JAMS, the mediation service there. Okay, so I think that concludes our what we're discussing on mediation. So if you the parties don't get an agreement through mediation, then the party probably the party who initiates a mediation is going to initiate arbitration, and that works pretty much the same way. But still, both parties need to agree on the arbitrator. If they don't, then I'm not exactly clear on how that's going to work. Maybe the party who is trying to initiate can compel the non-agreeing party to arbitrate. That is something that is that's a court action that I see occur quite often. Motion to compel. So in that case, there probably would be in that case there probably be litigation and a motion to compel the other party to arbitrate. Um, or I'm not sure how this works, and we're not going to get into these details. If the other party doesn't decide to um, arbitrate, even though they agreed to, maybe they just maybe the arbitration proceeds without that party's participation after notice and an opportunity to respond. And if that's the case, they have the it's kind of like maybe a default. I don't know. So I don't work in this area of dispute resolution. All I know is that it probably could go either one of those ways. If it goes to arbitration and you lose, the big point, and this is really the plot here. This is the point of this whole podcast today. If you get a decision in arbitration, which you will, um, is there any recourse after that? Can't.
No, it's final.
That's the point today. It's a final decision on the merits. Now, this assumes that you have an arbitrator hear the case on the merits. This assumes that you get, but you give both parties plenty of notice and an opportunity to respond. If one party decides to not participate after being compelled to participate after receiving plenty of notice, and that arbitrator awards the initiating party an arbitration award, that's going to be a final decision. Or if both parties participate, the arbitrator comes up with a decision that's going to be a final decision. So people often ask, is this going to be binding? Is this going to be final? Can you take it to court after that? And of course, the answer is no, it's final. I mean, you do need to take your arbitration award probably to court in order to collect. That's a little bit different. You're going to take it to confirm your arbitration award. The court is going to give you a judgment, and then you get to enforce the arbitration award through your normal collection of judgments, through the sheriff, through wage garnishments, through whatever assets you can collect on. So you do end up using the courts, but it's not for an appeal. So does that make sense so far?
Yes.
Okay. Well, I think we covered the big things here. So back to the exclusions, if you have an award or if you have a claim that's worth, in the less than $12,000, what are you going to do instead of arbitrate or mediate? What do you think? You could go to,
It's easy to go to small claims court. You also will not need an attorney there, and it can be resolved fast and with a judge. But
right?
you cannot shop for the judge. That's the thing.
Yeah, I like that discussion. Forum shopping, right? That's what it's called in law school. Forum shopping is can you or should you? It's against policy to forum shop in the courts of law. Some people see that they have the option to take a particular claim or dispute that they have to either a state court or federal court, and they call that forum shopping. Or maybe that there's different superior courts you could go to based on where the contract was signed, where the contract was performed, or where the it's hard to do it with some kinds of claims, and it's easier to do it with others. But the idea is that the courts want you to go to the correct forum, and if it's not the correct forum, then you're not going to be able to use that forum. In this case, with arbitration, you can forum shop. You get to shop around for your arbitrator. So, what do you think of that whole thing? We discussed it a little bit earlier.
Well, this is attractive. You can basically read the reviews and you can see who is more experienced and who is doing a good job. So this is kind of like a nice market, for shopping your judge, basically, whoever will decide the case. But on the other hand, with the court system, there are appeals. With the arbitration, there's none of this. So.
There's no appeal. I mentioned to you an arbitration award that was awarded here locally by a retired judge out of the Ventura Superior Court. A buyer purchased land. Actually, it was more than just land. It had a house on it, and she, I think, was using the purchase agreement. This page 14. I think both parties signed off on dispute resolution through mediation and arbitration. And as it turns out, the sellers did not disclose during the transaction problems with the property. There were, I don't know if it was landslide issues, had something to do with the settling of the property and the issues that could not be easily discovered by the buyer. Now, the buyer did discover some things and tried to get some further disclosure, but the sellers didn't. So instead, the sellers, I think, lied and covered up some of the issues. And the way it ended up was that there was a claim for misrepresentation, fraud, deceit, that kind of thing during the transaction. So the buyer initiates mediation. They don't come to an agreement. They go to arbitration. It goes to this one retired judge, and this is mentioned in our Ventura County Bar Association magazine that the judge awarded the buyer over $3 million as an arbitration award. What do you think?
That's not your small claims court, not it's a pretty serious judgment
Serious
and
judgment.
final. Final
Yep.
judgment.
And you can guess there were attorneys involved.
Absolutely.
There were attorneys involved on both sides. So don't let don't be deceived that just because it's mediation or arbitration that we're talking about small claims or small potatoes, as some people might say. And don't think that attorneys can't be involved. If you have a serious dispute, your attorney is going to help you through mediation and through arbitration. And just like in court, you don't have to have an attorney unless you're a corporation. If you're a corporation, then you need to have an attorney. A corporation cannot represent itself in court. LLC, whatever kind of entity, non individual. There's another important point to make about arbitration that is different than courts. That is the public nature of courts versus the private nature of arbitration. So arbitration is inherently private. It's not going to go to a public space where anybody could show up and listen to your case. For example, in a courtroom, it's not going to go into the court records, which can be searched by pretty much anybody unless the records are sealed. Arbitration is a private agreement, and that's attractive, I think, to a lot of people. Can you think of like who might that be attractive to?
People who has some kind of a public interest, who doesn't want to disclose their business.
Well, more like an interest in privacy.
Yeah.
Maybe a celebrity, maybe I mean, I think anybody would
Yeah,
see.
there's a lot of people who is very interested in privacy, so it's not just celebrities, it's you know your clients, you
Mhm.
know how it works.
Yeah. So now we have two big reasons as to why you might want to choose arbitration. One is maybe probably it's going to cost you less money unless you can go to small claims court. If you have a pretty simple claim and you know you're going to win and you can resolve it in small claims court without attorneys, then you're pretty much limited to $12,500. No attorneys are allowed. The costs are limited. Um, so that's an inexpensive claim and it's an inexpensive process. In small claims is great, but it doesn't apply to all cases like the one I just mentioned with out of Ventura County. That was a $3 million case that's not going to go to small claims.
When you sign this agreement, this is like your regular contract, purchase contract. You don't know what kind of problems may appear. So even if you're thinking about all of these things, you don't expect that there can be any kind of dispute while you're purchasing the property. So you cannot assess properly if it will be under $12,000 or over $12,000 because you just simply don't expect any problem.
Yeah, well, and I would hope that parties to a contract don't go into the contract expecting a dispute or with a dispute in mind already. That already sounds like fraud. That's true. At the early stage, you don't know what kind of dispute you're going to have, but you should know your clients and you should know at least a couple of these selling points about arbitration if it comes up. The first one being that it's a less expensive process. Know something about small claims. For example, small claims, the limit, you look it up. It changes sometimes. It used to be 10,000. Last I looked it up, it was 12,500. And then the other thing is the privacy. I think that's a huge benefit to people. You don't want people to know your business. You don't want people to, I mean, anytime a celebrity has a new action filed in court, what happens? It's all over the news.
Yeah, people are into your space.
Yeah. So I think having privacy. Maybe the third thing is you can do some forum shopping. You can
Oh, and not having an attorney. You don't have to have an attorney.
you don't have to have an attorney. That's true. That might be another thing, but I would say that having an attorney is a benefit for most people. I have some clients right now that they're not going to do any kind of dispute resolution without an attorney because they just don't feel comfortable doing it. So they've hired me to help them through the process, and it's a one of these contract matters. So um, I think the forum shopping thing is worth noting. You cannot forum shop in a court of law, but you can shop for your arbitrator. And there's a lot to be said about getting somebody who just works these kinds of cases all the time. I think you can find that arbitrator, the arbitrator who knows the contract, knows California real estate, Sure, judges will know the contract. They will know California real estate. They will know as good as anybody. But sometimes you get a judge that is less interested, or sometimes you get a judge who doesn't do this all the time, or the majority of their case load is something else, and they're not, they could be persuaded one way or the other by a very persuasive attorney on the other side, even though the decision is not wrong, not right. So, oh, the last thing, that just reminded me, back to this finality thing about arbitration awards. If you get an arbitration award that's not correct, what happens?
You can actually, it's not appeal. There's a provision like if the judge wasn't or arbitrator was dishonest or made some mistake.
Corrupt, conflicts of
Correct. Yeah,
interest.
there's like the whole line. Yeah, you can void the decision.
You can void decision on very narrow grounds. The arbitrator had to have been involved in some kind of misconduct, corruption, fraud, conflict of interest, failure to disqualify themselves. And that's another interesting thing about the arbitration under this purchase agreement is the arbitration will be subject to the California Code of Civil Procedure. So if the arbitration award is entered and the party does not like it, they can initiate litigation, but only on these narrow grounds under the California Code of Civil Procedure. And the Code of Civil Procedure lists these things that you're talking about: corruption, fraud, um, other misconduct by the arbitrator. We won't get into those details, but you're not going to get to challenge the merits of the case. You're not going to be able to relitigate the case. Well, as always, I would recommend if you have a dispute, contact an attorney. You can start with your agent if you want, but contact our office. My office is law4ca.com, LAW the number 4 ca like California.com. Also, Oli and I are in the real estate business, and we have other agents that work with us. You can check out our sales website, sold2000.com. We've got lots of years of experience in sales, and we understand this purchase agreement. We understand the issues, and we'd be happy to represent you through your sales transaction. Or if you have any questions after the fact and there's a dispute, contact my law office. Again, law4ca.com, and we'll talk about it. Initial consultation free of charge. Nothing in this podcast can be considered legal advice. Everybody's circumstances and case and facts will vary from one person to another. Before you rely on anything that we say, be sure you check with your attorney. If you want, you can contact us at law4ca.com. Thanks for listening.